Okay, I guess we'll get started. Thank you everybody for being prompt. Um, Hello, my name's Diane Sachs. I'll be your moderator for today's webinar, Carbon Pricing on Trial, unpacking the Supreme Court of Canada's decision yesterday and what it means for Canada. I'm pleased by acknowledging the Indigenous peoples of all the lands that we are on today. I'm in Toronto, the Dish from One Spoon territory and the traditional home of many Indigenous people, many of whom also live here today. Well, we meet here virtually. I would like to acknowledge the importance of the land that each of us call home. We do this to ground ourselves and to reaffirm our commitment and responsibility in improving relationships between nations and to improving our own understanding of local Indigenous people and cultures and their link with the land that we live and work on. From coast to coast to coast, we acknowledge the ancestral and unceded territory of all the Inuit, Métis, and First Nations people. Please join me in a moment of reflection to acknowledge the harms and mistakes of the past and to consider how we can each try to move forward in a spirit of reconciliation and collaboration. Today's webinar is co-hosted by Canada's Eco-Fiscal Commission, the Centre for Environmental Law and Global Sustainability, the Centre Québécois du Droit de l'Environnement, Eco-Justice, Public Law Centre, and the Smart Prosperity Institute. We'll hear from an expert panel of lawyers who argued the case and constitutional law scholars to explain the Supreme Court's decision and to discuss its implications for Canada, just in case you haven't read all the hundreds of pages yourself yet. We've got four great panelists today that I'm very pleased to be on with. Nathalie Chalifour, a law professor at the University of Ottawa, who was co-counsel for Friends of the Earth Canada and the National Association of Women in the Law. My friend Stuart Elgie, law professor at the University of Ottawa, counsel for the Eco-Fiscal Commission and chair of the Smart Prosperity Institute. We've got Joshua Ginsberg, director of the Eco-Justice Environmental Law Clinic at the University of Ottawa and counsel for the David Suzuki Foundation. David Robitaille, a professor at the University of Ottawa, faculty of law, who was representing the Centre Québécois du Droit de l'Environnement et Équiterre. And we also have Chris Reagan, director of McGill's Max Bell School of Public Policy and the chair of Canada's Eco-Fiscal Commission, which has written so much useful analysis on carbon pricing over the last many years. As I said, my name is Diane Sachs. I am an environmental and energy lawyer. I'm the head of Sachs Facts Law Professional Corporation. I'm the former environmental commissioner of Ontario. Our panel is going to be discussing the Supreme Court's decision, and we'll have time at the end for questions. Please do feel free to submit your questions using the Q&A box at the bottom of the screen. Given the large number of people attending today, you can understand we won't get through all the questions, but we'll do our best. You will see that there is simultaneous interpretation available through the event. If you look on your screen, you'll see a little picture of a globe with a table, the label interpretation. You can click that anytime you want to change the language. This event will be recorded so that it can be made available after today. It'll be on the Smart Prosperity website. It'll be on YouTube. And I'm sure it'll be available in many other ways. Yesterday was a really important day. We've had a long fight. We've spent 3 years haggling in Canada over the whole question of carbon pricing. It's like running to get your kids out of a burning house and there's someone clamping their teeth on your ankle just as you start to run. Well, we've spent 3 years to get that teeth off our ankle. Now our leg's free, that's great, but we've 3 years behind and the kids are still in the burning house. So it's been a sideshow. It's been a really important sideshow. We've got tremendous work ahead to do, but now we're going to think about and acknowledge the enormous amount of work that went into yesterday's decision and try to understand better what it is that the Supreme Court has said in its hundreds of pages. And we're going to start with Nathalie, who's going to give us an overview of what the court decided. Nathalie.
Thank you so much, Diane, and welcome to everybody on the webinar. This is a really big week for many of us who've been working on this case for some time. So what I'm going to do is speak briefly, as Diane said, about the ruling and try to give you a sense of the key legal questions. So first of all, we can say without a doubt that this ruling by the Supreme Court yesterday was historic. It was historic because the court ruled on the constitutionality of Canada's most significant to date climate change law, the Greenhouse Gas Pollution Pricing Act. And striking it down would have represented a major setback and made it really virtually impossible for us to meet our Paris targets, which are coming fast and furious. So it's extremely important in our national efforts to address climate change. Yet we all know that dealing with the complex and really multifaceted climate crisis is fraught in our federation, partly because of disputes about the division of powers and the ongoing intergovernmental debate that's characteristic of our political landscape. So there was great concern by some of the provinces about this law being a threat to federalism. Well, the decision that we heard yesterday, and it was many hundreds of pages, strikes what is a really reasonable balance between these two concerns. So what I'm going to do is explain to you the bare bones of the decision, and then the other panelists will elaborate on several of the key points. I'm going to share my screen. So what you'll see on the first screen is the key question that was asked of the court. So the first question that was asked, and this is a reference, so when provinces pose a question to their courts of appeal or it goes up to the Supreme Court, it is, in this case, a really simple question that was asked, and that's whether this federal law, JIPA as we call it for short, was constitutional, specifically whether it was within the federal government's power to enact it. So a couple of moments about the law itself for those who aren't familiar with it. The law was enacted in 2018, and it's basically to establish a national carbon price. So it puts a price on greenhouse gas emissions throughout the country. And now it's at about $30, not about, it's at $30 a ton, rising to $50 in 2022. And the price is achieved through two parts. So part one is essentially a levy on fuels. There's also in part two, something we call the output-based pricing system, which is basically a system for large industrial emitters that are potentially trade exposed. And so essentially they have to pay a price on emissions that are over a certain benchmark. But really importantly, and it was important in this ruling, the act is designed as what we call a backstop, which means that it only applies in the provinces or the territories that don't have an equivalent price. And so why carbon pricing? Because it's known to be effective in reducing emissions and it's cost effective. It also generates revenues, which are returned to the province, mostly in rebates to consumers. So how does the court answer this question that's asked about whether it's constitutional? It's really two parts, and it's quite simple. First, what is the law about? The courts call this pith and substance. What is it really about? And does that fall within a federal head of power? So the pith and substance debate was this. The provinces that challenged this, Alberta, Ontario, and Saskatchewan, said that this was basically about regulating all greenhouse gas emissions. It was very, very broad in their argument. In contrast, Canada and BC, who supported the Canadian position, said this was much more narrowly about changing behavior by setting a price. And there was some debate as to whether it's setting a national standard for greenhouse gas emissions more broadly, or even more specifically, setting national standards for greenhouse gas emissions reductions using a price mechanism. So that's the first question. The second question is, does it fall within a federal head of power? And so there's a menu of federal powers that exist. And the one that the Canadian government argued this law could be justified under is what we call POG, Peace, Order, and Good Government, specifically the National Concern Branch. Now, there are other powers, including the emergency branch of POG, criminal law power, taxation, trade and commerce. You're going to be hearing a little bit more about these other powers in the other panelists' comments, but they didn't end up playing a big part in the decision. And there were also broader arguments made with respect to Indigenous rights, the role of international treaties, and equality and charter values in interpreting the division of powers. You'll hear a little bit more about that too. So what did the courts below decide? The Saskatchewan Court of Appeal was the first out of the gates with its decision, and in a 3-2 ruling, so a majority of 3, minority of 2, dissent of 2, they ruled that it was constitutional. The Ontario Court of Appeal followed suit and also held that it was constitutional in a 4-1 judgment. So all of these judgments were split. The Alberta Court of Appeal disagreed, ruled it to be unconstitutional in a 4-1 decision. On fifth and substance, the majority said that it was the most narrow fifth and substance, specifically minimum national standards of price stringency for greenhouse gas emissions reductions. The Ontario Court of Appeal majority ruled that it was in fifth and substance about establishing minimum national standards of greenhouse gas emissions reductions across the country. So they didn't specify price stringency. And the Alberta Court of Appeal agreed with the provincial argument that it was just all greenhouse gas emissions reductions. And on heads of powers, the Saskatchewan and Alberta Court of Appeal, or Saskatchewan and Ontario Court of Appeals agreed it could be upheld under POG national concern, and the Alberta Court of Appeal said no, it's within provincial jurisdiction. So the Supreme Court, in a minute or two that's left, they, in a 6-3 ruling, upheld the law as constitutional. Chief Justice Wagner wrote the opinion, and with 5 other judges said, first of all, on fifth and substance, they agreed with the Saskatchewan Court of Appeals characterization of it as establishing minimum national standards of greenhouse gas price stringency to reduce emissions. So they did focus in on pricing. And on the head of power, they agreed that it could be upheld under POG national concern. There were dissents, 3 separate reasons, which again, I think you'll hear about in some of the other comments, and they ruled that it was not constitutional. So here's the test in a nutshell that you'll be hearing a little bit more about from the other panelists. Essentially, is the matter a national concern? The court said yes. This is an existential threat with extra provincial harms. Reducing national greenhouse gas emissions is key, and carbon pricing is critical for reducing greenhouse gas emissions. So they said that. Secondly, they said this law is clearly distinguishable from provincial matters. So this is something that we can identify. It's clearly distinguishable from the province, and there is a provincial inability to deal with this. So they've put a lot of emphasis on the fact that it's a collective action problem. And if one province doesn't play ball, there's grave extra provincial consequences for other provinces. That was key. And lastly, does the federal law have a scale of impact on provinces that's reconcilable with federalism? That's the balancing question. They said yes for 2 reasons. 1, it's limited to pricing, and 2, provincial laws continue to operate. There's a double aspect. So again, you may hear more about this from the other panelists, but I'm going to wrap it up because that's my time. Thanks.
Thank you, Natalie, for racing through 400 pages of decision in 7 minutes. Well done. You get a Sprint Award. So Stuart, you're next. So tell us, please, again, in a tremendously abbreviated format, what does this mean for climate policy, both federally and provincially in Canada?
Sure, I'll do my best. I'm the one with the least groovy background, but I do have a 10-week-old puppy behind me. So if you hear barking and chewing, that's not me. Let me talk about 2 things. I guess 3 actually. Federalism, what it means for climate legislation going forward, both federally and provincially. So Natalie talked to you about how the court defined the pith and substance, setting national minimum standards. And I want to just comment on that and say that it's actually not just a good approach for climate, it's a good approach for federalism as well. Because what it does is it allows both levels of government to play an effective role in dealing with greenhouse gas emissions. The federal government can deal with the national part, ensuring that our overall emissions meet our global targets. No province can do that on its own. But it leaves provinces free to calibrate their own laws to figure out how they reduce their emissions. Each province has different energy systems, different industry mixes, and so it's up to them to decide how to meet that target. All they have to do is ensure they meet the national standard. So it's a good approach because it lets both levels of government play an effective role, and we need both of them playing an effective role. It's kind of the approach we've used for healthcare in Canada for years too. Feds set minimum standards, provinces design their own systems as long as they meet the standards. And interestingly, it's the approach that many other federations use. The US uses it, Europe uses that same national standards approach. So it's a good one. what does it mean looking ahead for climate policy in Canada? Well, one big thing about the decision is the court was pretty clear that their national concern finding was limited to pricing, that they were not going to extend this to other types of regulation over buildings or vehicles. So what that means is the federal government will have to use other tools in its constitutional toolkit to deal with the many other aspects of reducing greenhouse gas emissions. The main one will be what's called the criminal law power, which Natalie mentioned, which sounds like we're going to criminalize it all, but it doesn't. It's the basis for most regulatory legislation federally. It's the basis for the Canadian Environmental Protection Act, upheld by the court in 1997 constitutionally. So the feds already use SEPA for regulations on an array of things: the coal phase out, methane, vehicle emissions, low carbon fuels. They have efficiency standards for appliances done under another act. So the federal government does have the ability to bring in a range of regulatory standards to deal with other aspects. It just can't use an explicit pricing approach, which was upheld in this act. It might be able to get to pricing if it were to bring in a cap and trade element to those other things, but it couldn't lead with a price approach as it is here. So the feds will be using other tools in the toolkit, but they'll be more regulatory in nature. And I think one of the big open questions is if they decide they want to get into buildings, because buildings is the one big part we haven't addressed yet, will they be able to do that under the criminal power? It's an uncharted territory. So lastly, what about provinces? The way the act is set up, the backstop allows provinces with equivalent legislation to take over the pricing regime. And most provinces and territories in whole or part have done that, but a number have not yet. And we heard yesterday speculation from Saskatchewan and Alberta, and probably Ontario soon too, that they may now bring in their own carbon pricing regimes to meet that test. Well, that means we've got to look more carefully at the test. And Chris may say more about this in his remarks, but at a high level, there's a couple of great big loopholes that have been put into the way the provinces have exploited those loopholes in the equivalency test. So one is the New Brunswick approach, which is in terms of putting a carbon price on fuels. New Brunswick brought in a carbon price on fuels equivalent to the federal minimum, but then it lowered their provincial gas tax on fuels by 80% of that amount. So the net effect is, instead of a $30 a ton tax, carbon tax on vehicles, there's about 1/5 of that, about $5 or $6 a ton. And Saskatchewan has indicated it may do the same thing. That completely undermines the purpose of this equivalency test, so it'll have to be looked at. And similarly, New Brunswick and to some extent Saskatchewan and Alberta have done the same for the industry emitters equivalent. They've said, yes, we'll put the same minimum price on industry, but what the equivalency test didn't do is talk about what the performance baseline for those industries have to be. And it's complicated, but the short version is this. The federal government basically says, we're going to set a performance standard based on the 80th or 90th percentile of the most effective firms in those sectors. You got to pay a price on every emission above that 80th or 90th percentile. So let's say 10 to 20% of your emissions at least. Some of these provinces instead are setting that standard really high. So essentially just meeting your current performance standards or reducing it by 1% is all you have to do. But they're saying, but wait, if you want to buy an offset or if you want to buy a credit, it'll be $30 a ton or $40 a ton, but nobody will need to buy a credit because there are virtually no emission reduction requirements. So those are two glaring loopholes in the equivalency test. Luckily, the Pan-Canadian framework has a review of those tests built in by 2022, and it's going to be important to make sure that those loopholes are closed up if provinces more and more are going to do equivalency. Thank you.
Thank you very much, Stuart. Well done. Joshua, two key questions for you. First of all, we know that hundreds of municipalities have recognized climate emergencies. The federal government has recognized a climate emergency. Did the court recognize a climate emergency? And what did the court do with the passionate arguments that the act gives too much discretion to the federal cabinet?
Thank you very much, Diane. And yes, on behalf of the David Suzuki Foundation, I, along with my co-counsel, made the argument from the other side of the peace, order, and good government coin. There's national concern, which Natalie very succinctly explained. And then there's also the emergency branch or formulation of the peace, order, and good government clause of the Constitution, which is invoked where temporary jurisdiction is necessary to meet a national crisis. And we said that the GGPPA is the quintessential emergency response because it's meant to get emissions under control very quickly and specifically within the short window that we have left to avoid the worst outcomes of climate change, a decade or less, to cut our emissions in half. That's urgent. And the temporariness, we said, was implicit in the 2030 short-term goal to slash emissions. So the purposes of this intervention were, I think, threefold. First of all, to really center the emergency and the existential nature of this crisis, which is related, but actually distinct from matters of national concern, which don't necessarily have that emergency element. Climate change does. And also explaining the function of pricing, the subject of this legislation, as a key measure to get emissions under control very quickly. And that's what the act is about, just that. It's not a broad federal power grab. And finally, to highlight not only the jurisdictional inability of provinces to address this collective action problem, because no one province can control what the rest of the others are doing, but the actual failure so far through evidence, the actual failure of provinces, many of them, to get emissions under control. Now, Diane, you asked, what did the court do with it? Well, they did not endorse or adopt the emergency argument specifically, but I would say that our intervention did have the desired effect of influencing the framing, because the court called this, in some of the strongest language we've ever seen on climate, a threat to the highest order to the country and the world, and that an undisputed existence of a threat to the future of humanity cannot be ignored. That is very compelling language. And the court also acknowledged that the provinces alone cannot address the climate crisis, and that leaving GHG controls to the provinces alone would cause profound nationwide harm. Very significant and a rebuke, frankly, to the provinces who said, leave it to us, you're in good hands, because we're not, clearly. And the court said that.
So you got 1 minute to talk about discretion.
Okay, I'm going to switch to that. Wow. So there's sometimes sort of an allergic reaction, just connecting it to emergency, that, even temporary jurisdiction can seem dictatorial. And that was actually a large feature of this judgment with respect to discretion, the Act's delegation of powers to the executive to modify elements of the regime. They call this the Henry VIII clause, the megalomaniacal sovereign who, among other misdeeds, usurped power from Parliament. And, it's ironic that the minority of the court would have voided the law on the basis of that executive jurisdiction, because so much environmental law is replete with really very unrestrained discretion. And Ecojustice, as a public interest environmental law organization, routinely chafes at such discretion. But now, in a situation where it is used legitimately to further an environmental goal, it's cast by a significant segment of the Supreme Court as somehow illegitimate. We say it's not, and I think the Chief Justice did a good job in dealing with it and calming those nerves. It's not actually unusual, and that's the last thing I'm going to say, I swear, it's not actually that unusual for clauses to modify the effects of statutes. Happens all the time. Now it's being done for a good environmental purpose. Thanks so much.
Thank you, Joshua. Sorry to be rushing everybody. There's so much we want to do today. David, you're our constitutional lawyer, and speaking from the point of view of Quebec, I know there's a lot of concern about whether or not this decision has eroded the power of provinces. And generally, Quebec is front of the line talking about that. Tell us, what do you see here?
Thank you for your question, Diane. Je dirais que, à mon avis, la juridiction des provinces reste largement intacte par suite de ce jugement de la Cour suprême du Canada, puisque la Cour suprême a quand même choisi, comme l'a expliqué la professeure Chalifour d'entrée de jeu, la qualification la plus stricte, la plus précise parmi les 3 ou 4 qui étaient invoqués par les plaideurs, les plaideuses dans cette cause-là. Et C'est d'ailleurs la qualification que le Centre québécois du droit de l'environnement et équitaire avait suggéré dès le litige devant la Cour d'appel de l'Ontario. Et à ce moment-là, on n'était pas très nombreux ou nombreuses à plaider ça. Hein. Au départ, plusieurs plaidaient que les GES en général étaient un enjeu d'intérêt national, ce qui aurait eu pour effet, effectivement, de permettre au Parlement et au gouvernement fédéral quand même d'adopter des normes sur un sujet très, très vaste et du coup réduire la capacité des provinces d'agir. Or, la Cour suprême du Canada, dans cette cause-ci, elle a été très claire et les motifs du juge Wagner sont soigneusement rédigés et personnellement, je trouve que c'est un jugement qui est très équilibré sur le plan du fédéralisme, qui vient appliquer la doctrine de l'intérêt national de façon raisonnable et quand même très précise, puisque ce que le Parlement peut faire et la nouvelle matière, le nouveau pouvoir que le Parlement acquiert, c'est celui d'imposer des normes nationales minimales de tarification sur les GES au Canada. Et donc, ça laisse la compétence provinciale largement intacte. Et j'entendais certains commentateurs hier au Québec en particulier s'inquiéter de la compétence provinciale en santé. Moi, je ne crois pas que ce jugement de la Cour suprême va mener à un élargissement excessif d'autres enjeux de compétences fédérales, puisque comme la professeure Chalifour et mes collègues l'ont mentionné, les changements climatiques, la crise climatique a un impact sur d'autres provinces. Là. La Cour a spécifié que 5 provinces sont responsables de 90 des émissions au Canada, tandis que les 5 autres provinces et les 3 territoires sont responsables pour 10. Donc, c'est vraiment un enjeu d'intérêt national véritable, puisque la pollution, en fait, les GES ne respectent pas, ne connaissent pas les frontières. Et donc, ce que les provinces vont continuer de pouvoir légiférer sur les changements climatiques, vont pouvoir continuer d'essayer de réduire les GES et même adopter des normes plus sévères que le fédéral si elles le souhaitent. Ce que les provinces ne pourront plus faire, et ça, je pense que c'est un prix raisonnable que le fédéralisme peut supporter, c'est d'adopter des normes en deçà et moins sévères que celles du fédéral. Donc, pour moi, la compétence des provinces reste largement intacte et c'était d'ailleurs l'un des objectifs que nous poursuivions comme intervenants dans cette cause-là, puisque c'est important pour la protection de l'environnement que tous les paliers aient des compétences importantes. Voilà.
Okay, good to know that at least from your point of view, there was no significant infringement on provincial jurisdiction. And it's good to hear a voice from Quebec, not worried about the federal government winning a case. That doesn't always happen. All right, Chris, you're on and you have 3 minutes to explain fully why carbon pricing matters and how this case changes carbon pricing in Canada going forward. Go.
Thank you, Diane. Thank you for having me. So I'm an economist. I'm not a legal expert. And as an economist, I guess I would make 3 points. Number one is, to me, the main point, the main takeaway for me from the Supreme Court decision is that the federal government can set a minimum standard for carbon pricing. And so that will not guarantee, but it will tend toward a common carbon price across the country. Now, some people would say that sounds like something that's a good thing because it's fair. The economist within me is not quite sure what fair really means, but we tend to focus on cost effectiveness. And if you actually have a carbon price that is being used to reduce emissions, and it is a carbon price that is approximately common across the country, then you get your emissions reductions at the lowest possible cost. And I think that should be of national concern, maybe not with a capital N, capital C, but I think cost effectiveness is really important when you're talking about reducing emissions. The second point is that the federal plan and its backstop is really pretty clear. And of course, it was modified and added to in December when the government announced that its carbon price would go to $170 per ton by 2030. And that is clearly the central plank, if you like, of the federal policy to 2030, and it will achieve the lion's share of the desired emissions reduction by 2030. There are many other policies that are being advocated, some of which are planned, some are not yet planned, but a carbon price that rises to $170 by 2030 is going to do most of the work. And I think that means we are using mostly cost-effective policies to get there, and I think that's a great thing. The third point, and here I'll overlap with Stuart, is that provinces now in this post-Supreme Court decision world, provinces have choices. The first choice is, do they want to simply accept the federal backstop? And I actually think we may see some smaller provinces, especially, that decide to say, well, we'll just let the feds do this. The federal backstop policy is actually a very well-designed policy. And I say that as an economist, not as a political expert that I'm not. But from an economic point of view, it's a well-designed policy. So I could easily imagine smaller provinces saying, let's just let the feds do it. But I think some of the larger provinces, both for economic and political reasons, may decide they want their own policy. And here they do have lots of choice. They can choose a carbon tax like British Columbia. They could choose a cap and trade like California, Quebec, that of course is linked to the California system. They would have complete discretion as to what to do with the revenues generated by the system. They could give them back as rebates. They could give all of them back as rebates. They could use it to invest in clean tech. They could use it to invest in infrastructure. They could use it to reduce corporate or personal income taxes. That discretion is clearly on the table. They also can design their system to deal with their emissions intensive and trade exposed sector in the way that they think is best. So there's lots of flexibility that the provinces have, but to finally overlap with Stuart on the loopholes, there are loopholes here. And I think both as an economist and as an environmentalist, I think we should be concerned about loopholes. But my prediction is that with this Supreme Court decision, the federal government now has the ability, I think, to dig in. They know they've got the law on their side. They can dig in and really defend, make sure that those loopholes are not taken advantage of. And hopefully, as a result, we can have a national set of policies that will do the job we need them to do. So let me stop there. I'm sure I'm over time.
Okay, thanks very much, Chris. All right, a few questions from me, and then we'll take a few questions from the audience. Reminder to the audience, please don't put things into the chat. If you have a question, please put it in the Q&A, and we'll get to as many of those as we can. So my first question, Josh, is for you. One of the reasons that the court decided that the national concern doctrine was invoked here was because we're already experiencing large impacts in Canada, and they called out in particular the disproportionate impact on Indigenous people. Given the increasing recognition of Indigenous rights, how do you see that affecting climate policy going forward?
Yes, thank you, Diane. And I think it's first worth pointing out. It may seem like an obvious point, but it can get lost in the din of everything, that this litigation was about what is permitted under the Constitution and the separation of powers, not about what, if anything, the government is required to do to address the climate crisis. And that is particularly acute when it comes to Indigenous people who are feeling the brunt of this. And the government, particularly the federal government, does have obligations toward Indigenous people under the honor of the Crown and the imperative to respect the treaty and inherent rights of nations. It was a little disappointing, I think, that the judgment didn't dig into that. It did, as you say, mention that the particular impacts on changes to the territory and traditional way of life of Indigenous people. For instance, another intervener, also represented by Eco-Justice, the Athabasca Chipewyan, pointed out that the projected change in temperature in their traditional territory is the equivalent of the difference in temperature between the average in Vancouver and the average in Mexico City. It's a huge impact. And so if in the future a government decides, as some politicians who aspire to lead have said, that they want to repeal this, then the question will be, what impact does that have on the honor of the Crown and derogation from the constitutionally protected and intrinsic rights of Indigenous people? And these sorts of questions are already being raised in lots of litigation around the country, in the federal courts and the provincial courts, stemming from the Charter and from Indigenous concerns. And in the future, I think any variation from this standard that has been set by this government and verified by the Supreme Court will be subject to further constitutional scrutiny.
So in other words, you're agreeing that Indigenous rights are going to start bearing on climate policy and climate law.
I am agreeing emphatically with that.
All right,
Absolutely.
I'm glad to hear that. Natalie, can you tell us briefly, what was it that you argued in front of the court and how did they respond? You've got about a minute.
Well, very quickly, and it builds a little bit on what Josh just said. I was representing Friends of the Earth and the National Association of Women in the Law, and we basically argued that as the court interprets its division of powers, it has to do so in a way that is also in line with charter values. And we didn't argue specifically Indigenous rights, but it was part of what we were saying, broader constitutional interpretation. And interestingly, while I'm with Josh, I'm being disappointed that the court didn't say more about the disproportionate impacts of climate change. They did refer to the disproportionate impacts of climate change on Canada as a whole, on Indigenous communities, on the North, on coastal regions. They did specify Indigenous peoples as being particularly vulnerable communities. They didn't go far enough, in my view, in talking about the disproportionate impacts on equality seeking groups, especially those that face systemic discrimination in our society. And so while that was a little bit disappointing, where they did bring those arguments out was in the interpretation of the test. So you'll recall I was talking about the national concern test, and is this a national concern? Well, that's where they pointed to these disproportionate impacts. So I think that's progress. Legally it's progress, because they said this is a national concern, partly for those reasons, because it is a climate injustice and there are going to be disproportionate impacts on certain regions and certain people. And lastly, on the scale of impact, so this case was very much about balancing federal and provincial interests and jurisdiction. We argued, and I think this was taken up, although it wasn't attributed to us, but there were other interveners who made it as well, including Indigenous representatives, that when you're talking about the scale of impact, you have to consider the scale of impact of upholding or not this federal legislation, not just on provincial jurisdiction, but on those other interests. And so the court did take that up. They talked in the scale of impact about including vulnerable people and the grave repercussions that this could have extra provincially. So I thought that was important, and it's a first step, if not the last.
Diane, you are muted.
Sorry about that. Do you see human rights law playing a significant role again in raising the minimum standard of climate action?
Was that directed to somebody?
Yes, sorry, Natalie, yes.
I mean, I think, again, like Josh said, this is once the Canadian government has pleaded these kinds of facts, and then they're on the record and they're accepted by the Supreme Court, it wouldn't be at all surprising if other litigants, whether in charter cases or in human rights litigation, can use that as part of their record and part of their arguments to justify arguments based on other legal theories.
Okay, fair enough. Yeah, so Joshua, going back to you, we've had a question. What about how timid the federal government has been? They've accepted equivalencies that are just ridiculously not equivalent. They've accepted a whole series of very weak provincial rules with these holes in it that Chris pointed out. Now that they have clear constitutional authority and a clear expression that, all right, if not exactly an emergency, then we're facing a major threat. Do you see the federal government actually stepping up and doing something more muscular?
Yes, I certainly think two elements to this. First of all, that the government is much bolder and more assured in implementing the benchmark that is set out under the GGPPA, and the indications that I believe David or perhaps Christopher mentioned, that the price will rise to where it has to go by 2023 in order to meet the challenge, that will be enforced across all equivalency decisions. And furthermore, the GGPPA is one important element to this. The other is accountability. And the GGPPA is meant to achieve certain goals. How do we know that we're on track? And what is the obligation of the government to ensure that we remain on track, including through its efforts to achieve equivalence. And that there's an important element for what's now Bill C-12, the Climate Accountability Act, to be a strong check and an assurance that our climate policy is actually leading us to the places we want to go.
Well, I'm glad you mentioned accountability. Certainly it's a sort of accountability act, but one of the questioners points out the Species at Risk Act includes an explicit backstop for species that has never been enforced. Stuart, do you see what do you see as the likelihood that the backstop here will actually be enforced, and who will enforce it? You're on mute.
Yeah, the backstop here happens in terms of advance approval. It's unlike backstops are common. Most federal environmental laws have a backstop. Species at Risk has it, SEPA has it, SIA has it. This one, it works ahead of time. So once the provincial regulation is ruled equivalent, it already comes in. And I guess if they change that law or stopped enforcing it, it could be enforced. But I mean, to me, that's really the real issue is how this is going to affect the continued fight over carbon pricing, right? We've seen this issue has really created gridlock in climate policy in Canada for the last really 13 years. And I think, my hope is that this decision will actually bring an end to these partisan wars we've seen, partly because that kind of policy instability just drives away investment. And we're going to lose, investors aren't going to invest in Canada. They're going to go to places that aren't ripping up their climate laws every time there's a change of government. The other reason is, though, as Diane said, pricing is important, but there's a whole bunch of other things we have to do to move to a net zero future. And all of this fighting over pricing has prevented us from getting on with things like building codes, stronger regulations of industry, tax support for clean tech investment, low carbon infrastructure. Let's get past this partisan fighting the way we've gotten past in other big issues in the past. We used to have big partisan fights over healthcare, free trade, and after the dust up has ended, parties have come together historically in Canada. Hopefully we'll do the same thing on this.
Yeah, for sure. David, we've had a few questions about the criminal law power. So as we heard from Stuart, the court was very specific. This national concern was restricted to pricing. That national concern did not extend to everything to reduce greenhouse gases. So what can the federal government really do with the criminal law power, given the primary provincial jurisdiction over property, civil rights, and natural resources?
That's a really good question. I think that that the federal government has a lot of a beaucoup de marge de manœuvre pour utiliser son pouvoir en droit criminel. D'ailleurs, il y a une décision de la Cour d'appel fédérale que la Cour suprême a refusé d'entendre en appel, qui a confirmé, par exemple, que le gouvernement fédéral pouvait utiliser la loi sur les espèces en péril pour protéger la rainette faugrillon. C'est une autre cause dans laquelle le CQDE est intervenu en faveur du gouvernement fédéral. Et donc, le pouvoir en matière criminelle est interprété très largement par la Cour suprême et nos tribunaux. Et donc, ça permet, c'est une disposition qui permettrait au Parlement d'agir de façon efficace et assez large en environnement pour les années à venir.
So you're optimistic?
Oh yeah, I'm optimistic because the Supreme Court of Canada has clearly recognized that the Parliament has a role to play to protect the environment through its criminal law power.
Okay, I hope you're right. So, Chris, can you talk for a minute about the cap and trade prices in Quebec and Nova Scotia? Their price, they've got a carbon price, but it's really, really low. It doesn't match the federal carbon tax. How is that equivalent, and what do they have to do about it?
Great question. So when the federal government and the provinces came up with a pan-Canadian framework, and I thought there was a very deft political decision that was made, which was, basically the decision was you need to have a carbon price across the country, whatever jurisdiction you're in. And you can choose whether it's a carbon tax or a cap and trade system. And then at that point, but there was no need to compare the two systems. So if you had a carbon tax, then the carbon tax had to rise at a particular rate given by the federal backstop. If you chose a cap and trade system, then the cap had to decline at a particular rate, which the Quebec cap does. But I actually think that was both a deft political move because it avoided the need to compare the BC system to the Quebec system, for example. But it also economically, I think, was the correct way to do things because the proper way to judge the stringency of a cap and trade system isn't by looking at the price, but it's by looking at the cap. And sometimes if there's a big business boom or if there's a recession, the price will be volatile in a cap and trade system. And that's not an indication that the system isn't working. In fact, that's an indication that the system is working exactly as designed. So I think the focus needs to be basically on where the cap is going if you choose a cap and trade system, or where the price or tax is going if you choose a carbon tax. So it'll be interesting to see whether, Alberta, Ontario, Saskatchewan, for example, if they choose their own system, whether they choose a BC-like tax with the word tax in it, or whether they choose a Quebec-style cap and trade system.
So in other words, Chris, by Ontario backing out of our cap and trade system, which I always argued was better for Ontario, Mr. Ford guaranteed that we're going to have higher carbon prices in Ontario than Quebec is going to have. Very cool.
Well, that's possible. It also depends on who else is part of the cap and trade system.
Yeah, no, for
right now, having California connected to the Quebec cap and trade system through the WCI, that almost certainly is keeping the price of permits down.
But anyway,
otherwise would be.
But it would be okay to have a lower price. That's the key point. Natalie, we had a question from why is it that the court treated the balance of powers in federalism, which is of interest primarily to lawyers, as equally important as climate change, which threatens the survival of humanity and civilization?
It's a great question. And it's because I think it raises a real problem. So as my brilliant colleague, Professor Linda Collins, has argued before, there is, this argument that there should be an unwritten constitutional principle that informs the interpretation of everything in the Constitution. So the argument I was mentioning earlier that I've made from an equality perspective is one that I think should infuse interpretation of division of powers and other things. But the whole I think in this case they had to do something to balance federalism with the environmental principles that were argued. But the argument that we don't have an economy, we don't have anything, we don't have human health without a functional ecosystem and a functional climate. And so this argument that we should balance them and trade them off each other, I think is fallacious. And I think that's something that the court, as I mentioned earlier, got one step closer towards, but still has a long way to go because they did look at this as a balancing exercise versus suggesting that there's a fundamental level of environmental rights that should be recognized first and foremost, and then that we should be talking about division of powers as a follow-up to that.
Sounds good. David, you wanted to...
Yeah, thank you, Diane. As Professor Chalifot noted, that's a great question, but we have to remind that unfortunately, regarding the division of power, the protection of the environment is not an end in itself. And at the heart of our Constitution, there's the balance between diversity and unity. And since the beginning, the Supreme Court of Canada and the Privy Council before that, many times are argued or established that this balance is at the heart of our country. And so that's the reason why it's so important for the Supreme Court.
Stuart.
There's two different factors at play in this federal-provincial tension. So think of back when Stephen Harper was Prime Minister and BC was bringing in ambitious climate policy. Everybody liked provincial leadership back then, or in the US when California was getting ahead of Bush. And so there's this race to the top dynamic that you actually want to allow ambitious provinces like Quebec or BC to be bringing in innovative regulations. You don't want the federal government to crowd them out. But at the same time, you want the federal government to set this minimum floor and prevent a race to the bottom. And so what the court has tried to do is to strike a path that allows both to happen, which is consistent with federalism, to ensure that no province can kind of do this race to the bottom on low standards, but to now allow enough room for ambitious provinces to get ahead of the federal government and try new stuff. If BC hadn't been able to move ahead with its carbon tax since 2008, we wouldn't be having this discussion. Just like in the US, if California hadn't been able to go ahead on vehicle standards or cap and trade in the Bush years or the Trump years, the US would be way behind where it is. So climate change is an important goal, but actually allowing both levels of government to play on it is really important.
Yeah, I agree with that, Stuart, although I think you should also mention the municipalities, which in many cases are the real innovators.
Yeah, so that the Constitution doesn't give them constitutional power.
That's another problem. Joshua, let's think about the worldwide effort to have climate change recognized by the courts as something on which they will make decisions, and their willingness to push governments. We saw in this case that previous decisions like Urgenda are being cited over and over. So what role do you think this Canadian decision will play in furthering climate action in other countries?
Yeah, it's an important point. It was great to see Urgenda cited, and particularly for the proposition that a de minimis argument, meaning, oh, our jurisdiction doesn't emit that much, we're a drop in the bucket, that was not accepted as a reason to deny that one province's emissions can have an effect on others. So that was a great interplay of the international jurisprudence. And I hope that in turn, this judgment will inspire and influence other jurisdictions who are considering a pricing tool. Now, we know in the United States that the government has become much more ambitious than the previous government. I understand that there's not an intention to directly price carbon, but there will be a social cost of carbon implemented when approvals are being considered. And under the previous administration, that was set at $8 a ton, and now it's more in line with our standard, which is currently 50. I hope that this judgment stands as a message to other federal states that national pricing can be implemented in a way that is not destructive of the balance between the various orders of government.
So too. Natalie, Patricia asks us what we think the impact of this decision is going to be on Bill C-12, which seems to be sort of stuck. And it's stuck both from the right and from the left. I mean, the climate activists know that it's a very weak bill. It's called climate accountability, but doesn't actually have any accountability in it, except that you have to file some reports. And then you've got all the climate denialists who don't want to see the federal government pushing, or thinks that the act doesn't do very much. So it seems to be stalled. Do you see this decision having much power to break that deadlock?
Good question. I've been thinking about it. I think it certainly moves us, again, a step or two forward, because that bill has been really carefully drafted on the basis that there's an uncertain level of jurisdiction. That didn't presume that the federal government would have jurisdiction to tell the provinces what, to allocate a budget or a proportion of emissions. Had this decision come out and suggested perhaps a broader pith and substance, and perhaps not specifying price stringency, but just saying that generally there's an authority under national concern for governments to set GHG emissions reductions targets, that might have given some leeway to a kind of a budgeting exercise, which of course would be better as a negotiated outcome between jurisdictions, but it could have opened the door to there being some kind of, top-down allocation process, legally speaking. But the fact that the court focused in on stringency of pricing, I think limits that. So what impact will it have on the bill in general remains to be seen. It didn't set back the bill because, as you mentioned, Diane, the bill's already fairly modest in its undertakings, but it certainly didn't do anything to make it more difficult.
Okay, well, thank you very much, everybody. I think we're going to have to start wrapping up. we have lots more questions. We could have a great conversation, I know, for more hours. I look forward to having more conversation with many of you. And in fact, we are going to have more conversation about this on Tuesday, March 30th. We're going to have a event on the politics of carbon pricing, where I will be again I'll be a panelist instead of a moderator. It's called The Politics of Carbon Pricing, What Does the Supreme Court Decision Mean for the Future of Climate Policy in Canada? You'll see the registration link in the chat. You can also get it, of course, on the Smart Prosperity website. Please come back and join us again. But thank you to each of the panelists, and thank you for working so hard to stay within our very tight timeframes. Thanks to the hardworking team that made this possible. Thank you to everybody who stayed up late reading the Supreme Court decision so that we could discuss it in so much detail. Thanks to the organizations who co-hosted and co-sponsored today's conversation. Thank you everyone for joining us today. Just a reminder, this has been recorded. It will be posted. It'll be posted on the Smart Prosperity website. It'll be on their YouTube channel. Those of us individually participating may also be posting it. So we do want people to hear this conversation. Please pass it on to others. So thank you very much, everybody. We got good news yesterday. We've got an enormous amount of work to do if we want to have a chance at a stable climate. So everybody, please take a deep breath and then go at it. See you on Tuesday.